So, what if I told you there's a federal law out there, one that every single state has to enforce, that could literally cost your family their home? I know, it sounds crazy, but it's a law most seniors and their kids have never even heard of, and its impact can be absolutely devastating. Let's get into it. $300,000. Just look at that number. That's the average amount of home equity that families are losing. Why? Simply because they don't know this law exists. It can wipe out a whole lifetime of work, just like that. All right, so what are we actually talking about here? It's called the Medicaid Estate Recovery Program. You got to go all the way back to 1993 when Congress passed this law. It basically says that states must try to get back the money they spent on long-term care. And we're not just talking about nursing homes. This also covers assisted living and even in-home care that Medicaid paid for. The rule applies to anyone over 55 who got those benefits. Okay, so how does the state actually get its hands on the house? Well, there are 5 main ways, and we're going to break down every single one. First up is the most common one, the probate claim. And this happens in all 50 states. There are no exceptions.
The process is pretty simple, but it's brutal. If a parent's house is just in their name when they pass away, the house has to go through probate. And you know what? That's exactly when the state makes its move. They file a claim, and here's the kicker. Their claim gets paid before anyone named in the will gets a single dime.
Let's make this real for a second. Imagine your parents' home, maybe the one you grew up in. Let's say it's valued at $400,000. That's their nest egg, right? The legacy they worked their entire lives to build for you and your family. But what if your parent needed 3 years of nursing home care? Well, at an average of about $120,000 a year, that is a huge bill. And now the state has a claim against the house for the full amount, $360,000. So after the state takes its massive $360,000 cut, this is what's left, $40,000. That's it, for the kids to split. The family's main asset is almost completely gone. So you might be thinking, are there any exceptions, any way out? Well, yes, but they are incredibly narrow. The state can't collect while a surviving spouse is still alive, or if there's a minor child or a blind or permanently disabled child living in the home. But, and this is a huge but, the claim doesn't just disappear. Oh no, the state just waits. They can wait for 10, 20, even 30 years. And the moment that last protected person passes away, the state comes right back to collect on the care for both parents. And believe it or not, it actually gets worse. The next 2 threats are even more aggressive, and they often catch families completely off guard. Okay, threat number 2 is something called a TFRA lien. This is a game changer. It allows the state to put a lien on the home while the Medicaid recipient is still alive. This usually happens when they're considered permanently institutionalized, which is a fancy way of saying they're probably never coming home. This lien gets attached right to the deed, locking in the state's claim before the person even passes away. And this isn't just some legal theory. This plays out in the real world. I mean, look at this story out of Indiana. A daughter was driving past her father's house every week, paying the property taxes, paying the insurance, doing everything right. She had no idea the state had already slapped a $270,000 lien on it. She only found out after he died that she would never, ever inherit a single dollar from that house she was trying so hard to protect. And that brings us to threat number 3. Expanded estate recovery. Now, over 20 states, we're talking places like New York, Ohio, Connecticut, have taken this even more aggressive route. They go after the very things families were told would keep their assets safe and avoid probate, things like living trusts, jointly held property, and life estates.
So imagine this. You pay an attorney thousands of dollars to set up a living trust, thinking your home is protected. But in one of these expanded recovery states, that trust might offer 0 protection from Medicaid. A family in Connecticut found this out the hard way. A $240,000 claim was filed against their living trust. It forced a 79-year-old widow to sell her home and move in with her daughter. Absolutely heartbreaking.
All right, now for our final 2 threats. And these are particularly nasty because they target the so-called safety nets and can even put the kids on the hook for the debt personally. So with all this, is there any way out? Did Congress build in some kind of escape hatch? Well, they did. It's called a hardship waiver. On paper, it's supposed to protect families from undue hardship, but does it actually work? The truth is, the huge majority of these waiver applications are denied. And why is that? Well, for one, the state has a direct financial incentive to say no. Some states even hire outside recovery firms that get to keep a percentage of whatever they collect. I mean, look at the case of the son in Ohio who cared for his mother for 18 months. His waiver was denied because he was just 6 months short of a 2-year minimum caregiver rule. He was forced to sell the family home. And now, we've arrived at the final threat. This is the one almost nobody sees coming. It's the 5-year look-back trap. Now, we've all probably heard you can't just give away your assets within 5 years of applying for Medicaid. But here's the twist no one tells you about. If the parent dies during the penalty period that Medicaid imposes, the state can come after the person who received the asset, personally. So in this example, the daughter who got the house is now personally liable for a $180,000 Medicaid bill. The very thing she did to try and protect the house is what made her responsible for the debt. Okay, I know that was a lot of really scary information. I get it. But the good news is, you are not powerless here. There are real, concrete steps you can take to protect your family's home. So let's dive into the solution. Here are 5 things you can literally do this week. First, investigate. Find out if your state is an expanded recovery state. You have to know the rules of the game you're playing. Second, stop all informal deed transfers. Please don't just add a kid's name to the deed. Third, go consult with an elder law attorney. Ask them about the most powerful tool you have. Fourth, if a parent is already in a nursing home, demand to get their intent to return home status in writing. And fifth, if a claim has already been filed against you, do not pay a cent until you have had a legal consultation. Look, at the end of the day, the single most powerful way to protect your home is with something called an irrevocable trust. But there's a huge deadline attached. The house has to be put into the trust for more than 5 years before Medicaid is ever needed. Once you clear that 5-year mark, the house is legally outside of your parents' estate, and it's safe from all of these recovery tricks. Your family home, it's so much more than just a building, right? It's a legacy. It's memories. And now that you know how the system really works, you have the power to protect that legacy. So the only real question left is, will you?